Okay, anything that you want to add?
The only thing I want to add is that is a trial process just the starting point to a whole process of wanting to find whether someone is guilty or not. So you are tried by court number 1, and then the law allows court number 2, which is the Supreme Court in this case. There's also even court number 3, and our duty as lawyers, as my colleagues have said, is to pay. So we very much believe that at the end of the legal process, our clients will be out.
Do you still believe in the justice system? I mean, many people, some of the families feel that this is not just, and they are disgruntled with the justice system.
We will still believe in. That's why we're going to pursue it. What has happened is it happens in many legal systems. You get to the trial court, it comes up with that. In fact, most of the work of the Supreme Court and others is to set aside judgments of lower courts. And there are many of them. It's a daily event. So we are convinced that based on what we did in the trial and on the evidence and so forth, a Supreme Court will not reach the same conclusion as the trial court.
To come to a different finding, and our client reserves the right to challenge this decision to the Superior Court, and those are our instructions for now.
What was the selling of money laundering? What did you make out of it?
The state was not clear in respect of what it wants to do, and it has said it wants to sleep over it. So we let them sleep over it, and then we'll deal with whatever they decide to do. But if they intend to move in terms of Section 50, there are clear procedures in terms of how they must move, and it should not affect how the trial is progressing. Because right now, what is now before the court is the issue of sentencing, and which is different from the Section 50 that they were referring to. So they have not even decided what they want to do. We do not know what they want to do, so we'll let them sleep over it.
Yeah, just to add on from what my colleague has said. Yes, indeed, we are disappointed with the judgment. Both of them have been convicted, but we still have other remedies. We can still appeal, but before we appeal, we still have to go through the process of the sentencing itself. So when they are sentenced, that's when these proceedings in the High Court terminate. And then after that, we can then approach the Supreme Court. We strongly feel that there are very, very many points that we can raise in the Supreme Court. But at this point, we will not get into that. We'll get the whole judgment, and once they are then sentenced, we'll then do the proper appeals. An appeal is a public record. We'll then obviously share it with the media at the time that the appeal is filed. But yeah, there are many, many points that we could see and clearly read from the judgment where we feel strongly that there were some kind of misdirections on the part of the court, especially on factual issues. Yeah, but for now, that is all that we have to say.
But are you at all surprised by the ruling, given that along this trial, you have tried so many times to get the judge recused? Especially, I've read some of the papers that you have filed in court where the judge at one point said your clients are never going to win any application before.
No, look, we remember we did file an application for recusal, which we then at some point withdrew due to some other reasons. We would not say that we're expecting that our clients were to be convicted. We put up a good fight as a legal team, and we are convinced with the arguments that we made in their defense throughout the whole trial. And we are sure, as my colleague has said, that is another court sitting differently may come to a different finding. So that's our response to your question.
Thank you.